My name is Jean Sternlight. I am Director of the Saltman Center for Conflict Resolution. I am very delighted to introduce our speaker, Michael Helfand, who comes to us by way of Pepperdine University School of Law, where he is a professor. He's also the Associate Director of the Glaser Institute of Jewish Studies there. And he's speaking tonight on what I think, and I hope you all think, because you're here, is a really fascinating topic, the relationship between religious arbitration tribunals and civil courts, and whether and when and if civil courts should enforce orders that may have been issued, awards that may have been made by an arbitrator. I'm not going to spend too much more of the time on the introduction, other than to tell you that Michael is very accomplished. He's still fairly young, still fairly new to academia, and yet he has published a bunch of really impressive articles. He's got a book forthcoming with Cambridge University Press. So we are delighted, with no further ado, to welcome him to up here, Michael, and look forward to your talk. I think, do you want to entertain questions as you're speaking, or save them to the end? Okay, so if you have questions as you speak, very good. You can raise your hand, and also there will be question and answer at the end. So thank you all so much.
Two quick things. One, I'm getting over a cold, so excuse me if I keep this hot drink with me as I make my way through the evening. Number two, my favorite thing I've ever done speaking is I once got up to speak and somebody had a question before I even said a word. I was like, oh my God, that's amazing. So please feel free anytime. You can leave right now if you have a question. That's perfectly fine with me. We can jump right in. So thank you so much to UNLV for hosting me. It's been a wonderful day here. I had a chance to speak to the faculty this afternoon, and now this late afternoon, early evening. Really a pleasure to be here speaking to you today. My topic for today is between law and religion, when religious law meets arbitration, and Professor Sternlight already gave you a little bit of a sense of what I'd like to talk about today. And to give you kind of a little bit of bigger sense of what the goals for the talk are, I have two primary goals of what I would like to do this evening. What I'd like to do this evening is, first of all, to give you a sense of what United States law does with religious law. Is it law? Is it religion? Is it both? And why should we care? And second, what I'd like to advocate ever so slightly while we're chatting here today is to express why I think United States law should treat religious law a little bit more like law and a little bit less like religion. That's kind of where I'm going. And I'd like to convince you that this matters. This isn't just kind of an academic conversation about high theory, how this should work, but really how it should impact concrete cases that matter deeply to lots of people. Now, to do this, what I'm going to do is I'm going to talk a little bit about United States arbitration doctrine. How many people in the room love arbitration, participate in arbitration in any sort of legal capacity? Okay, we got one confident hand in the back and a couple other wishy-washy folks in the middle. That's fine with me. Sounds great. So let me say just a little bit by way of background about arbitration. So here's what we've got. If you're thinking about arbitration, it really involves two parties using agreements to submit a dispute instead of going to court. They use an arbitration agreement to submit a dispute to a third party neutral. And amazingly, after you sign up for arbitration, you say, I would like A, B, and C, or maybe just A, to resolve my dispute over contract Y. When they issue an award, an arbitration award, the winner can walk into court and say, Judge, I'd like you to take this piece of paper and turn it into an enforceable judgment. And the judge gets to sprinkle his magic dust, judge dust on top of the award. And it's an enforceable judgment. You can do all the fun things we do with judgments. We can garnish somebody's wages or lien on their property, all the things that bring smiles to lawyers' faces. You know what I'm talking about, right? Fantastic. And amazingly, over the past 30 years, the United States arbitration doctrine has increasingly said, we are really pro-arbitration. We think arbitration is a really good way to resolve disputes. We're both going to enforce agreements and enforce awards more and more than we really ever have before. Now, that in and of itself is its own, I think, very interesting topic. But one of the things that has happened as arbitration has ascended in the U.S. legal landscape, religious communities have said to themselves, that's an interesting way to do business. And what we'd like to do is we'd like to take our own religious infrastructure and model it around arbitration doctrine and say, we're going to resolve our own internal disputes under the rubric of religious arbitration. And so you have now a lot of groups in the United States, I would say most prominently the Jewish community, the Muslim community in the United States, using religious arbitration to get enforceable judgments. Now, what is a religious arbitration agreement? How would you know one if you saw one? So you would probably see two of the following things in a religious arbitration agreement. First, you would see a religious arbitration provision. It would be a provision that basically identifies a particular religious authority or religious authorities to resolve a dispute. And then you see a choice of law provision, a provision that says, here's the law that's going to govern the dispute. So now you see laws that either say halakha, or Jewish law will govern a dispute, or Islamic or Sharia law will govern a dispute, or the law of the Bible will govern a dispute. I was just mentioning earlier today, there was an article in the New York Times, maybe a couple months ago, where you had a couple of verses from Matthew, or what's called the Matthew Clause, that governed a dispute between a university and its president, and there were a couple $1 million on the line. And the question was whether or not you could, to what extent would the arbitration be governed by verses in Matthew. And that's okay, so long as the arbitrators abide by Matthew, that type of award is enforceable in court. Now, a religious tribunal is going to apply religious law in two basic ways. First of all, they're going to use religious law to determine the substantive outcome of a dispute. So we have a dispute over a particular contract, and they're going to take contract law from whatever religious law has been incorporated into the agreement. And on top of that, they're also going to have the procedures of the arbitration. Things like when you meet, who the arbitrators are, what kind of notice, all those procedural rules that you normally get from the governing state or federal law. They're going to use religious law to figure out how exactly the procedures of the arbitration should work. And if you do these two things, religious communities have realized that they can use the enforcement power of the United States to ensure that the decisions of their religious tribunals are enforceable. Now, what's amazing about this whole system is there's really been a symbiotic relationship between these religious tribunals and United States constitutional law. You're probably thinking to yourself as you hear me recount this, if you've never heard anything about this, that seems a little bit strange. How does that work with the First Amendment? The idea that we have disputes being governed by religious law, and you walk into court and the court says, yeah, that's fine with us. So here's what you want to keep in mind. The way it works is, normally, so for maybe even take a further step back, we have a First Amendment that has an establishment clause. An establishment clause prohibits all arms of government from establishing religion. And it also prohibits courts from resolving religious questions, known as the religious question doctrine. A court can't say, oh, let's take a good fun example. There's currently a class action lawsuit against Hebrew National. You know, they answer to a higher authority, but you know the company, fantastic. It's a class action lawsuit saying that they engage in fraud and their food isn't really kosher. And so the purported class would like them now to answer, I guess, to a lower authority. We're with you on that. Okay, good. And so they'd like them to go to court, and Hebrew National says, you as a court can't decide whether or not our food is kosher. To do something like that would violate the religious question doctrine, and as a result would be a violation of the Establishment Clause. Let me give you some other examples of this kind of religious question doctrine. A case in New Jersey, maybe 2009, I want to say, Abdul Haq v. Jewish Press. Plaintiff is a high-risk obstetrics doctor. And unfortunately, he's in the process of divorcing his wife. And his wife calls up the local Jewish newspaper and says, my husband is refusing to give me a Jewish divorce. This is a big deal in the Jewish community, refusing to give his wife a Jewish divorce, not letting her move on with her life. And so she calls up the newspaper, lists the names of husbands who are refusing to give their wives Jewish divorces. This is bad news. You don't want to be on this list. And so the newspaper, before it went ahead and published the husband's name, called up the relevant rabbinical court and said, is this guy really refusing to give the divorce? They said, yeah, he is. Turned out, no, he wasn't. So they list his name, and everybody sees it. And all this guy's clients, he's a high-risk obstetrics doctor. It turned out most of his clients are Orthodox Jewish women. So they all call him up and say, we're not going to use you anymore as a doctor. He loses hundreds of thousands of dollars a year. So what does he do? He sues the newspaper for defamation, right? Okay, they walk into New Jersey court, and you know what the court says? The court says we can't be in the business of figuring out whether or not this defamation claim can go forward. This defamation claim cannot go forward. Because to do so would entangle us in religious questions, and as a result, we're going to have to dismiss the dispute. Now, if you ask me, the court got it wrong. But this is the type of thing that courts do. And so they dismiss the claim on religious question grounds. Now, this is curious, but it's also a big problem for our poor plaintiff, because now he's got nowhere to go, and he's got no business. This is the type of issue that courts can't resolve. I'll give you another one. This is my absolute favorite one. I've already mentioned it earlier today. An imam in Arkansas, 2009 also, what a year. And the imam in Arkansas has a lifetime contract. He can only be terminated from the mosque for cause. And as it turns out, after a couple of years, his congregants get together and they say, it's been great having you, but it turns out your sermons are awful. And so we're terminating you for cause. And the imam says, what? My sermons are great. What do you mean they're awful? Didn't you hear them? They're inspiring, they're fantastic. So they terminate him. He goes to court and he says, I was wrongfully terminated. The mosque says, you were wrongfully terminated. Your sermons stink. He says, my sermons are great. And the court is now faced with the prospect of trying to figure out whether or not there was cause for his termination based on an evaluation of the sermons. And once again, what's the answer? The answer is the court can't do this. Why can't it? Because the court can't be involved in trying to figure out what the standard is for a good Islamic sermon, and then evaluating whether this particular sermon met that religious standard. Now, so you say to yourself, what are plaintiffs like this supposed to do? And the answer is, this is where religious arbitration plays a really important role. You see, if you have an arbitration agreement, let's say like the imam, you have an arbitration agreement, which he kind of did have, although it was a little bit more complicated than that. Let's say you have a religious arbitration agreement, you can, instead of going to court, submit the dispute to religious arbitrators, and they are allowed to decide a religious question. The First Amendment doesn't apply to them, and they're allowed to engage in religious questions, evaluate them, and they can resolve that issue, render an award, and then that award can be walked into court, and the court can then thereby make sure that it's enforceable. And in that way, people who have jobs that entail certain type of religious obligations, they can actually get protection, if not from a court, from religious arbitrators. They get those protections from religious arbitrators, they get enforceable awards, they have their day in court, and they can receive some sort of justice. I call this the gap-filling role of religious arbitration, right? If we didn't have religious arbitration, people who had these kinds of jobs would just be out of luck. And now we have an opportunity where people can actually get these disputes resolved, but the important piece is you can have it resolved and enforced without the court ever having to decide a religious question itself. It just kind of farms it out to the arbitrators, so to speak. The arbitrators do the religious question, they bring it back to court, and then you have enforceable award, question in the back.
Would the religious arbitrator be analogous to administrative remedy, or is that different?
And
Would the religious arbitration proceeding be analogous to an administrative remedy prior to going to court to have that judgment?
in what respect analogous?
Because it's not a court of law.
That's right. So it's not state action.
Right.
That's kind of what courts have held. Some people think that's wrong. But generally, we don't think of arbitrators as engaged in state action. And because they're not engaged in state action, they can't violate the Constitution, or they can't use the provisions of the Constitution. So that's exactly why you can walk it in. And because the way it's supposed to work, set up for arbitration, you don't want people having two bites at the apple. So the arbitrators decide the merits of the dispute. They render an award. That award just says A owes B 10 grand. That then goes to the court, and the court says, do you have enforceable arbitration agreements? Is everything, so to speak, lack of a better word, kosher? And they determine everything's fine, and then you can go ahead and do again all the fun stuff that lawyers do. Yes.
Can you appeal that religious arbitration decision?
To whom?
That's my question.
So the answer is depends what the arbitration procedures are for a particular, like any arbitration system. I happen to work with a rabbinical court that has an appeals process, but it's a matter of contract, not a matter of right. This is kind of why, like, when you look at the surveys for why people like arbitration in certain companies, they like the non-appealability. I think 1, 2, 3, let's get through. We're done.
If you guys go to judicial appeal, a petition, if it's arbitrary capricious, you guys can always make that shot. Slim and none chance to succeed.
So we'll talk in a very brief second about what are the grounds that you can use in order. So that's 9 U.S.C. Section 10, Federal Arbitration Act, and obviously for other states, and that's kind of what we're going to talk about in a brief second. So I've tried to explain a little bit about how the substantive part of this works, right? We farm it out to our religious arbitrators. They do kind of all the religious stuff that they need to do. Then it comes into court. We assume we work, make sure that it's enforceable, and then you have an actual judgment. Now, I say all this and how it's great, and the reason it works for the Establishment Clause is the court isn't the one deciding the religious question, it's the arbitrators, but you still have a little bit of a problem. And where this problem comes in is when you're dealing with not the substantive merits of the dispute, but when you're dealing with the process by which you administer the dispute, so the procedural rules that govern the arbitration. Now, The Federal Arbitration Act has a list of procedural rules that you need to follow. If you violate these procedural rules, we're not going to enforce your award. And these include things like corruption or fraud, evident partiality of the arbitrators, failure to admit pertinent material evidence, things like that, ways in which arbitrators screw up procedurally. And if they run afoul of any of these things, a court's going to say, no, we can't enforce the award. That's what the statute says. Also, courts must check whether or not the contractually agreed upon processes were followed by the arbitrators as well. If you said, arbitrators, you need to give us 10 depositions, and you wrote that into a contract, and the arbitrators only allowed each party 5 depositions, that could potentially be a ground to vacate a subsequent arbitration award, not because the statute demanded it, but because the two parties agreed upon it, and the arbitrators failed to implement the arbitration agreement as agreed upon by the parties. So this latter issue of trying to police the procedural rules that govern arbitration has become much more problematic than the substantive part, right? The substantive part is that to you, it's really great, right? Arbitrators do it, and then the court never needs to review it again. But the procedural part, this is where courts play an important role. It's only a fair process to the extent you abide by the statute and by the contract. And there, courts have an important policing function to play. Now, this latter issue in the context of religious arbitration has come up on a number of occasions recently. There's a 2011 Florida court that was reviewing an arbitration award, and they said what they need to figure out is whether or not the arbitration tribunal complied with, quote, ecclesiastical Islamic law. Now, when this decision hit the internet, people went crazy. And people went crazy because they said, and this is part of the larger anti-Sharia movement, oh my goodness, courts are enforcing Sharia law. And then people kind of went bonkers, newspapers all said a whole bunch of crazy stuff because that's literally their job. The George orders, there's one newspaper title, judge orders use of Sharia in suit. Like, okay, whatever, fine. And then there's another one, a Florida judge decided, quote, to apply Islamic law instead of state or federal statutes, as if somehow the federal constitution has now been preempted. Now, of course, you can probably figure out what was going on over here. You had a contract that said, here's the dispute, you need to resolve this contract dispute, and guess what? The procedural rules that apply to this dispute are ecclesiastical Islamic ones, so the judge was doing exactly what he was supposed to do, right? The judge is trying to figure out whether or not the arbitrators abided by the agreements of the parties. Just here's the problem, right? How's the judge going to figure that out? Can't figure out what kosher is. How's he going to figure out whether or not the parties abided by ecclesiastical Islamic law? I'll give you another one. There's been a bunch of litigation in the Church of Scientology. Church of Scientology has everyone sign arbitration agreements, and these arbitration agreements require that all the arbitrators be members of the church in good standing. Now, we're not going to talk anymore about the details. We can kind of spin this all out in a variety of fun ways. The court has enforced the arbitration agreement, meaning it's telling the parties that they need to go forward with the arbitration. But what about the award? How are we going to figure out whether or not requiring people to be members of the Church of Scientology in good standing complies with the procedural statutory requirements of, say, arbitrators can't be evidently partial? Well, we're going to have to figure out what it means to be a member of the Church of Scientology in good standing. And you can see how very quickly you would get at the procedural requirement, the procedural safeguard that's made to make sure that the process of arbitration is fair to both parties, how enforcing that for a court starts creating a real problem. How are courts going to enforce these kinds of procedural rules? The substantive part is fine. The court doesn't need to look at it again. You did your job. That's great. But the procedural rules, which are there to protect the inherent fairness of the arbitration, what are courts supposed to do with those? And that's kind of what I want to talk about today. I want to talk about what we thought about having a title for this talk. The subtitle was something along the lines of procedural challenges to religious arbitration rules. That sounds terribly boring, so we didn't put that in the title. We put something else. But now I've gotten you on Sharia and Church of Scientology and good standing, and you begin to see that the ability for us to police the fairness of these kinds of arbitration is what's at stake over here. The ability of religious communities potentially to kind of run roughshod over individual members and not give them the kind of decision-making process that they signed up for. Now the question is, how do we deal with this? And what I hope to show you in the next little bit is how the complications in these kinds of cases show how the United States law, I would say, is almost what I call in the abstract Janus space. So like On the one hand, it looks at it like law, on the other hand, it looks at it like religion, and by not being decisive about how it wants to think about religious law, it puts this whole process in big danger. So that's the goal for the rest of the talk today. That's what I want to show you. That's kind of the problem that we're going to deal with. And to do this, what I'd like to do is I'd like to walk you through just one hypothetical case. It's really going to take us through most of the talk. So, the reason I ended up with this hypothetical case is because, like most of my stories, they start with a phone call. Somebody called me up one day and says, I got a question. I'm like, sure, fire away. He says, let's say my client says to me he went to a rabbinical court arbitration and the arbitrators refused to admit one of his witnesses because she was female. I'm like, is that what happened? He's like, I'm not sure if that's what happened. The answer is no, that's not what happened. But he's like, let's say it is what happened, because that's what his client says maybe happened. Okay, fine. So, turns out it didn't happen, but it's super an interesting case. I wonder how that would work. Rabbinical courts can rarely apply this rule. If you look for all reported cases in all federal and state courts, you would find no such case. But it's a useful case. How would we want to approach a situation where a rabbinical court or Islamic court under Islamic law for rules of testimony, 2 women equal 1 man, classical rule under Jewish law, a woman can't testify on commercial matters. So what will we do with such a case? Now, when I present this, the classic lawyer response is the following. Oh, that's an easy case. 9 U.S.C. Section 10 tells us where the arbitrators were guilty of misconduct and refusing to hear evidence pertinent and material to the controversy. If that's what happened, then you vacate the award. And so the lawyer says, well, they refused to hear evidence that was pertinent and material to the controversy, and therefore we should vacate the award. Everybody with me? That's a fair argument. That sounds pretty good. It's a mistake, though. That was a little bit of a trap. And here's why. Let's think about this for a second. So imagine I have an arbitration agreement that incorporates Swiss law. Okay? And I have no idea what Swiss law says on this, so I'm literally making this up. And imagine it incorporates Swiss law, and Swiss law says that you can't admit video evidence video evidence is inadmissible. Why? Because the kids these days, they play with those computer things and they can make it do anything. So we don't admit any video evidence anymore. You have to have eyewitness testimony or something else like that. Okay. So, and we have an arbitration agreement and it says that arbitrators have to use Swiss law. But wouldn't you know, one of the parties shows, but you know, I have they pull out well, you wouldn't pull out a video cassette anymore, you don't have those, but you pull out something or another. I have a thumb drive that has everything on it that you would ever need, right? And we can show it to you and you can see exactly what happened. And the arbitrators say, we can't look at that. That's video evidence. And the arbitration agreement says, you can't look at video evidence. Now, if the arbitrator said no video evidence, would we say they're not refusing to look at evidence that is pertinent and material to the controversy? The answer is presumably no. It's not pertinent and material. Why isn't it pertinent and material? Because the law that you incorporated that decides what's admissible and not admissible determines what's pertinent and material. We usually most people have a very different instinct when it comes to religious law, and that's probably the reason I'll talk about in a second. But when you think about it that way, if you've incorporated a body of law that says no female testimony, then that female testimony isn't pertinent and material. And so failure to admit a female witness would thereby not be a ground to vacate the award. That's just puzzling kind of outcome, but it seems right if you think about it. And the reason why it's right is because for these purposes we would treat religious law like law. It's like Swiss law. The law governs how the terms of the arbitration work, how we apply the statute, and it's because we treat religious law like law that this wouldn't serve as a ground to vacate the award. Now people hear this and like, holy cow, that can't be right. There's got to be a gazillion other reasons why we're going to vacate this award. Most people usually say something like the public policy exception. So you can't have an arbitration award that violates public policy, and maybe that would be the reason why we vacate this award. And maybe that's right. I think it might not be. And the reason is because there are a whole bunch of limitations on the public policy exception. For one, the Supreme Court cast some doubt on the viability of the public policy exception in 2007 in the case called Whole Street Associates v. Patel, where they said there are no non-statutory grounds for vacature. Federal courts of appeals are split on this. It's a mess. So maybe there is no public policy exception. Let's say that's wrong. Let's say there is a public policy exception. There probably is. Supreme Court has also said that a violation of public policy would need to be evident on the face of an award. And as long as the arbitrators wouldn't write, and we decided not to have female testimony on the face of the award, if they just wrote AO's B $10,000, we wouldn't be able to satisfy that. Let's say we have ways to overcome all that. The court has also said any violations of public policy must violate positive law, and for reasons that are kind of obvious, but funny, I guess now, there's no law that says you can't have gender discrimination in arbitral testimony. I mean, there's a reason why, because who does that? But there's no such positive law, right? There's not like another title of the 1964 Civil Rights Act that covers this type of conduct. We have firing, a variety of things, but not for this. And so we might not have positive law in these circumstances. So if we were just putting our lawyer hats on for a second and saying, how do we attack a case like this? The answer might be the public policy exception is the wrong tool. I've elsewhere discussed how maybe we could use unconscionability to attack this type of award where the award was made subsequent by the refusal of arbitrators to admit female testimony. I will leave that aside for now. But trust me when I say the following. There's no obvious reason why you would vacate an award where arbitrators refuse to admit female testimony. And again, the fact that that's true because the law as an instinct treats religious law as law. As a result, the court can't reject an award for failure to admit pertinent material evidence. The selective law determines the scope of the material and the language of the statute, and alternative sensibilities may very well lack the doctrinal hook to require the opposite outcome. Okay, so that's one little piece of this. But as I tried to express already at the outset, that's only half the story. So in that way, we treat religious law like law. But a lot of the claims here might not just be that, hey, you failed to admit female testimony, but part of it may be, wait a second, that's not what religious law requires. Now, one of the reasons, again, why you have no reported cases in the context of no court arbitration of failure to admit female testimony is because over the past 1,000 years, Jewish law has developed in a way where there are so many exceptions to this rule. It's like, as opposed to Swiss cheese, it's like the opposite. It's like little pieces of cheese. Like there's almost nothing left to the rule, and so nobody really uses this rule at all anymore. And so imagine a rabbinical tribunal one day comes along and says, now we're going to enforce it. We haven't done it in like 800 years, but like today's the day, it's Tuesday. If we do this, maybe we can get out fast. For whatever reason, they decide we're going to say no female testimony today. And the claim now that a plaintiff wants to bring is not just failure to admit, but you got the religious law wrong. And I want to push that as an argument in court. What would a court do with that kind of argument? Well, I've already told you, right? Courts can't investigate religious questions. They wouldn't be able to interrogate whether a religious doctrine actually does or does not require the admission of female testimony. Now, for other bits of law, if you had some violation of a procedural rule or some sort of other requirement where the arbitrators are required to apply some other brand of law, courts would try to figure out whether or not there is what we call manifest disregard of the law. Whether or not the arbitrators knew what the right law was. They stared at the law, they said, we know what it is, we don't care, we're going to apply something else. You don't often win on this claim, but at least you've got a shot. You figure out whether or not the arbitrators knowingly rejected the applicable law. This is something that, while available for all other forms of law, would not be available for religious law. And if you want to know the reason why is because we don't just treat religious law like law, we treat religious law like religion. And it falls under the First Amendment, and it's got that little shield from the Establishment Clause that says, courts don't tread here. Now, once courts can't figure out whether or not, they're not allowed to interrogate whether or not there was a violation of religious law, they actually therefore have to confirm the award. They have to say, this award goes through and we're going to enforce it. And that's just a function of the statute. The statute says, 9 U.S.C. 9, quote, the court must grant such an order, referring to an order to confirm the award. The court must grant such an order unless the award is vacated, modified, or corrected. Now here, if we can't figure out whether or not the arbitrators failed to abide by the contractually required procedural rules, you can't vacate it. And if you can't vacate it, you've got only one thing you can do with it, and that's confirm it. And again, the reason you can't figure out whether or not you're going to vacate it is because for these purposes, we treat religious law like religion. We don't treat religious law like other forms of law. Okay, so big picture. Here's what I tried to do so far. When it comes to engaging these religious law, the United States law is a little bit schizophrenic. On the one hand, when it comes to defining the relevant procedural categories when it comes to arbitration, we treat religious law like law. When it comes to investigating the application of religious procedural law, we treat religious law like religion. And together, what this dynamic does is it serves to insulate religious tribunals from interrogation of their procedure agreements. What do we do with all this? Great question. Glad you asked. I can think of three basic categories of what we should think about all this. So here are the three categories. 1, rejection. 2, deference. 3, demystification. Spoiler alert, I'm going to go with 3. But let me walk you through 1 and 2 first. So first is rejection. Maybe the answer to all of this is the following. This is a mess. This is one whole mess, right? What should we do about this? Maybe we should just close the courthouse doors to religious law altogether. We can't handle it, and we can't handle it precisely because we can't get at it in any way. The Constitution requires one thing, the statute requires another thing. It's too much for courts to handle, and so let's just close the courthouse doors to religious law. Now, this might be a charitable and, in my view, unduly charitable way to explain the anti-Sharia laws that kind of have run across, I don't know, I think we're up to 9 states right now. Over half the states that consider anti-Sharia laws. And these anti-Sharia laws attempt to prohibit courts from considering religious law in any way in their decisions. And so maybe that's why. Maybe it's simply too complicated. Once we let religious law in, we can't figure out what to do with it. Let's just say no to religious law. Now, I think rejection is the wrong approach for a couple of reasons. The first is, it's not clear what the alternative is. So, first of all, having religious arbitration allows parties, and I haven't said a lot about this, but allows parties to resolve disputes in accordance with their shared values. And in quite a lot of cases, it ensures that they can go to someone who understands what they parties perceive as their religious obligations and allows them to experience the resolution of dispute in that context. That's a pretty powerful thing. That's a way in which we enhance religious freedom in the dispute resolution process, and that's probably not something we want to just discard and lose completely. Second of all, we need religious tribunals for that reason I talked about all the way in the beginning. Remember the gap-filling function. What about all those folks that aren't going to be able to walk into court? The person who was sold kosher food when it wasn't really kosher. The imam who, everyone says the sermons are bad, but he believes would have liked a third-party neutral to be able to take a look at it. Or the doctor who has been defamed and has lost his business, and courts have said, I'm sorry, we can't figure that out for you. All these people should have the opportunity to go somewhere to get some sort of justice. And if we simply reject the entire system of religious law, we're telling all these people, no justice for you. And that seems unacceptable. So to completely reject it, rejection seems like the wrong answer. So if rejection is wrong, let's try option 2. Maybe deference is the answer in this case. Maybe what we should do is, this is fine. We can't get at religious law, but that's okay, because maybe what we really want is to give power to religious institutions to decide religious questions and religious issues. And that's not for us as a judicial system or as a society to kind of trespass on. We want to give them that power. You want to participate in a religious community. You should have the ability to do so, and we're going to defer on that count. Now, I think that's wrong also. And the reason is because it gives the judicial system no opportunity to ensure that parties, people who have decided to submit disputes for religious arbitration, that they're getting what they signed up for. Parties won't have confidence that they will receive the benefits of the religious rules that they bargained for, that they contracted for, and there's no way to reject an award if we simply defer where the procedural rules are a function of fraud or manipulation as opposed to genuine religious learning. And so I don't think it can be right that we're simply going to defer fully in all circumstances and say this kind of hybrid way of viewing religious law, part religion, part law, we can't get at it because it's law, and then we can't get at it because it's religion. The answer shouldn't be, that's fine. Let's just defer to the religious tribunal. So what I'd like to offer is the beginnings of an agenda of trying to demystify religious law. What I mean by that, we should just start trying to think of religious law a little bit more like law, and maybe a little bit less like religion. I've argued in a couple of places that back in the day, like 1870s to 1950s, courts were far more willing to get in the weeds when it came to religious questions. They were willing to answer what seemed like debates over what religion required. There was a case in 1872, the Supreme Court says, if there's an express trust, and that trust is only going to go to a particular institution, if it's Trinitarian as opposed to Unitarian, courts have to figure out whether it's Trinitarian and Unitarian. And guess what? That's a religious question. Trying to figure out that kind of theology, and the Supreme Court seemed okay with it for quite some time. Only when we hit the 60s and 70s did we start having increasing numbers of reservations about courts trying to figure out the answers to religious questions. I think we can do a lot more with it. In fact, we used to have a way of interrogating just generally the conduct of religious institutions for fraud, collusion, or arbitrariness when it came to constitutional issues, things we don't do anymore. And in those back in from, I would say, 1870s again to the 1950s, courts expressed far more willingness to try to figure out, are we getting religion right? Now, when I say that I'm in favor of this, I'm not saying that I want to inject courts into religion full on, and courts should start becoming theological institutions. Who knows, they can start ordaining people and all the good fun that might come along with it. But what they can do in some circumstances is serve as a backstop to ensure that, at least in the context of arbitration, religious tribunals aren't intentionally manipulating religious procedural rules. They can step in and uphold the religious procedural rules that people want, that people join communities because they want true religious learning, and they want the opportunity to have a religious process that captures those intuitions. Now, if we find ways to limit arbitration doctrine to those contexts, these extreme contexts where we say to ourselves, you know, religious law is a little bit like law, and just like for other forms of law, we ask questions like, has there been manifest disregard of the law? And we don't say to ourselves, no, that's way beyond the type of thing we can allow courts to engage in. If we kind of open up courts, kind of get rid of those handcuffs ever so slightly, courts can start trying to figure out, I don't know, whether or not somebody's using an arbitration provision where they say that we can only have members of the Church of Scientology in good standing. Those are the only people who can resolve the dispute. Maybe we can try and figure out whether or not that's a good thing or a bad thing, whether that's going to give us a fair procedure or an unfair procedure. And only then enforce those arbitration awards. In so doing, I think seeing religious law as more like law and a little less like religion can help protect the institutional infrastructure that makes this type of religious freedom possible. Thank you.